So AH is desperate. We're talking about out-and-out desperation, too, because of this little word. What's it called again? Oh, yeah, accountability. Sing it with me. Accountability. Man, that was terrible. Tug's gonna sing a song. Let your cat shriek along. In all seriousness, though, the document that you and I are going to look at today, it showcases that she's no longer in the driver's seat. She can no longer take the offensive and say, Johnny Depp, he's X because of incident 1 through 14. No, it's costing her money. It's costing her reputation, and the case, it gets bigger by the moment. See, they mention over 50 audio tapes that have yet to be produced in this. They show a witness list, people we have never seen before. It's interesting. They mean to say one thing, talking about, poor courtroom, you don't need to have your time wasted, and they end up saying a lot more. Fun times, huh? Fun times. So hey there. So today we return to that wonderful world of Johnny Depp coverage. And like I've said many times, this is absolutely imperative, not because of a superstar out there in Hollywood, but because someone was falsely accused. They deserve due process. And who exactly is going to fight for them if all of us don't speak up? So this document is interesting because it's pretty much AH and her lawyers trying to cause Johnny Depp problems because Fantastic Beasts 3 is coming up. He actually has work, and she's getting eaten alive by court costs. She wants things here. She wants things now. And what you find out when they're telling you this, well, like I said, it's pretty interesting. So plaintiff elected to bring this suit in Virginia, and as such, necessarily agreed to adhere to the rules of this court. This court clearly communicated to the parties that they would be treated the same as all litigants appearing in this court. Yet plaintiff now requests this court to effectively stay these proceedings and delay plaintiff's deposition. So that's interesting, right? You're going to have new deposition in this. So you're going to have not only plaintiff, but defendant's deposition, the way this will play, for 5 months while he travels to the UK for business. This is not good cause under. They give you the reason for that. And granting the request would set a highly problematic precedent. Now this is interesting because anything that's done with Johnny Depp, it can be done to AH as well. And imagine this. I mean, we've seen her deposition before. So on August 7th, 2020, plaintiff was properly noticed for deposition lasting up to 5 days. So if he's deposed for 5 days, again, you saw her video where she's eating chips and acting like an out-and-out lunatic. Imagine the kind of entertainment that we would have. Plaintiff was invited to inform of any conflicts or alternative dates. Counsel for defendant learned through Warner Brothers counsel, not through plaintiff, that plaintiff has no intention of appearing at this deposition. Now, I found this disclosure very telling, considering she's the one calling Warner Brothers, and yet he supposedly is targeting Aquaman too. I mean, you see a little problem in that, right? She's using that as a defense, and yet, well, you see exactly where her efforts lie. Continuing, when parties to litigation face conflicts, it is incumbent upon them to find solutions such that the judicially scheduled dates are prioritized for the effective administration of justice. Yet the plaintiff made no effort whatsoever. Counsel for defendant received no response to her question about those efforts. She proactively reached out to Warner Brothers counsel, aka the place that she works for, the case that Johnny Depp works for. She went after them to cause problems. Make no mistake, pulling them into this issue, this is trying to cause him problems. Continuing, although plaintiff has been contacted in late June or July with the proposed filming dates, he did not alert them to the trial dates or the deposition. Instead, he waited until now and specifically requested the letter attached to the motion for continuance. Plaintiff determined that rather than speak with his employer to work his film commitments around the deposition and trial, plaintiff is not filming throughout the entire 5 months. He has periods off, and in spite of Plaintiff is being the plaintiff in this action, he asks this court to subserviently reschedule around his employment and the entire film schedule and production. Again, they're desperate. They want to harm him with this. And again, you see who they're taking aim at. Got to make it difficult so he loses money. Plaintiff also claims the counterclaims justify continuing the trial. However, plaintiff provides no basis for why he cannot adequately prepare within 5 months between the filing of the counterclaims and trial and refuse to respond to defendant's questions on the issue. You better tell me now. With respect to count 1 of the counterclaim, count 1 of the counterclaims, basically free speech, my free speech. Plaintiff has indicated he is asserting the same claim as against defendant. Basically, if she's going to say that, well, I'm going to say it back. Counterclaim 2, which is defamation, and defamation per se, is effectively the mirror of plaintiff's defamation claims, which is not actually true. If you look at what he's responding to, he's responding to court case. What she's doing, she's responding to, well, herself. She's made these accusations. So really, look at the distinction. In count 3, we're talking about her wanting him to be a computer felon, is based on the conduct by plaintiff and his counsel, Mr. Waldman, which is a daily campaign to destroy defendant's reputation and career through social media, the internet, and the press. Even though, again, you can refer to claim after claim, day after day, and see where she and her people have contacted the press to weaponize them. Telling stuff. Plaintiffs should be well prepared to defend against these actions, which need to stop. Then only a trial will effectively end this campaign of terror orchestrated by plaintiff. Campaign of terror indeed. Do you see the desperation in that? Oh my God, we've got to end this, because if we don't end this, my reputation is going to suffer even more. And she's going to tell you through this that she's already having trouble getting any jobs. I mean, it's right down here. People know her for who she is. And well, if people don't start shutting up, oh my God, I'll never have a job again. Fun times, huh? Fun times. Prejudice is not a factor, it continues, for the court in determining whether to grant a continuance, but if it were, defendant would be significantly prejudiced. She has expended a significant amount of legal fees and costs defending this litigation, which will only increase exponentially with a 5-month hiatus and continuance. Defendant's career has virtually halted, with the exception of Aquaman 2, which she was told months ago would begin filming in February of 2021. So you see this. Money, my job's fallen off. Oh, well, except for Aquaman. So remember that too. Go out and make your voice heard. Continuing, Warner Brothers counsel said they did not know when Aquaman 2 will begin filming, but will be sometime in the spring of 2021, which is also a basis for denying the continuance. If filming of plaintiff's movie is a good cause, then this case could be continued again if defendant's filming begins through its duration and so on, establishing a slippery slope precedent. This court recognized the importance of strict adherence to trial schedules in its practice manual. So they quote the practice manual. The judges of Fairfax County Circuit Court believe that the maintenance of strict calendar control leads to a more expeditious and efficient administration of justice, even though we have canceled the trial a couple of times because, of course, we have the beer bug going on. Continuing. This case has already been continued twice because I forgot this was here. I said that as a joke, and it's actually here, which is good cause. Plaintiff's motion should be denied, and plaintiff should be ordered to appear at his deposition, as noted, subject to reasonable beer bug protocols. So it was okay to delay it because of beer bug, but when you start things up because of beer bug, well, that's not a good reason. Makes sense, doesn't it? Yeah, makes sense indeed. Statement of key facts. Summary of issues. On the 18th of May, 2020, plaintiff participated in setting the January 11, 2021 trial date, estimated to last 3 weeks. So we know 3 weeks duration, no matter what comes up. That's what you should plan on, no matter where it lands. On August 7th, defendant noticed a plaintiff deposition for up to a week in Virginia beginning October 5th, 2020, to which defendant has not objected to place or dates, has provided no alternative dates, or objected to suggested protocol. Plaintiff did not meet and confer before filing this motion, has refused to respond to defendant's questions or provide any information on when plaintiff first learned of the filming schedule, plaintiff's efforts to schedule around deposition and trial, and plaintiff's time off during the filming. After plaintiff refused to respond to these reasonable questions, defendant issued expedited discovery requests asking for the responses to be provided to defendant by September 1st, otherwise due September 10th. Plaintiff did not respond to the email request for information for a meet and confer, did not expedite any responses, and has not responded as of the filing of this opposition 2 weeks later. With no information provided by counsel, look at this here. Counsel for defendant reached out to Warner Brothers and learned that plaintiff would have been contacted in late June or July to discuss the rescheduling of the film, and that contrary to plaintiff's representation, he learned well before the August 19th letter. In fact, plaintiff requested the letter from Warner Brothers. It was not sent in the ordinary course of business, nor was this how or when plaintiff learned of filming schedule. So why this is done, in my opinion, is, well, it's possibly twofold. Number one, again, you could be trying to damage Johnny Depp, or you could be trying to motivate him to expedite all of this stuff because you're afraid of what might come out in the proverbial wash if you wait another few months. See, we keep seeing people come forward and tell their tales. Well, if you give people a few more months to think about it, how many more stories might come up? Might be some interesting stuff indeed. Counsel for defendant even then reached out and asked for all dates between August 26th and October 1st when plaintiff would be able for deposition, and plaintiff only suggested they were looking at London in late September by WebEx, but never provided any specifics. You know, because all of these places out there, they haven't been absolute in their filming schedules, but hey, you need to hammer them down and you need to say this is what I'm going to do. Doesn't work that way at all. This court should not condone nor begin a precedent that a plaintiff who chooses to bring an action in this court will be entitled continuances based on work schedules, particularly when plaintiff has made no effort to work around the film schedule, refused to meet and confer, provided no evidence of efforts to adjust his work schedules, and eschewing his deposition without even telling or working with counsel for defendant when she reached out. Now, I love this. Check this out. Nor should this court determine that an actor who chose not to bring this case in California is more important than any other employee in Virginia and should receive special consideration. It's funny that somebody that out and out manipulates, that tries to get special consideration all the time. I mean, look at all of the crazy that she's done and how she's done it, would complain about this specific thing. That kind of cracked me up. This court takes pride in holding its trials within 1 year of filing, with rare exception. While the beer bug has caused unprecedented delays to ensure the safety of the judiciary, the staff, and participants in the legal system, the court should not dilute the significance of challenges faced by the courts, granting a continuance for the wrong reasons. You know, because again, if it impacted the judiciary, that was wrong. We needed to set it back. But if it impacts other people's lives, if it impacts you being able to make money, yeah, not about that. That is especially true when plaintiff has not taken his responsibilities as a party seriously, has not complied with the rules in bringing this motion, has not cooperated with defendant in trying to work through this core issues, and has still, as of filing this motion, not provided even one document in response to 4 sets of RFPs, all served in July and long overdue, in spite of the court's admonishments that documents need to be produced in compliance with the rules. This includes, look at this here, the withholding of 50 to 51 tape recordings possessed by plaintiff where the defendant is on the tapes. These were not produced in the UK proceedings, suggesting they are quite damaging to plaintiff. Now, I'm curious what is out there, because again, if they're saying there are 50 to 51 tape recordings, they're assuming what would be on said tapes. I'm curious how they would know about that, number one. But number two, like I said, I'm curious what's on it, and especially considering you never know what might be waiting for old AH in the States. I mean, that has to be worrisome for them. And in fact, I'm sure that they want to know what's there, have them turned over, because they don't want any quote-unquote surprises. While plaintiff now seeks a continuance of up to 5 months with no intention of producing plaintiff for deposition in the interim, plaintiff's counsel, Mr. Adam Waldman, who is thus far refusing to show up for his notice deposition in October, continues to disseminate false information in the media and circulate declarations with the header of this case purporting to include highly inflammatory quote-unquote testimony that has never been filed with this court or provided to counsel for defendant. They're talking about some of the declarations we've covered. Like I said, those are important because they showcase who this person is. AH and her people, they know that, and it scares them because they know they're losing hearts and minds. They know this stuff. It is costing them, and it should be. They want to say, ooh, they're trying to ruin me. No, we're just getting to know you for real. This case has generated an enormous amount of publicity, much of which was falsely created and disseminated by Mr. DEPP and his agents. Remember, all of you bots out there, intended to inflict irreparable damage to defendant in her reputation and profession. Plaintiff's counsel continues to try to prejudice the Fairfax County jury pool and public opinion against defendant through this constant, caustic, and inflammatory media commentary related to this case. So now he's not only going out doing all of these other things, but he's also trying to quote-unquote prejudice the Fairfax County jury pool. Isn't that telling? Can you imagine the long game that some of these people imagine? They should write spy novels, I'm telling you. Continuing, just this summer, Mr. Waldron repeatedly referred to defendant's DV allegations on social media as a hoax, has retweeted false and defamatory allegations about defendant's relationship with other people, has attacked defendant's counsel, and flagrantly disregarded this court's repeated admonishments that to not litigate this case in the press rather than in Fairfax courtroom. And perhaps most concerning, Mr. Waldman has leaked documents that were clearly designated confidential under the protective order in this case to the press in a further attempt to smear defendant. Dun, dun, dun. Defendant intends to vindicate herself at trial, yet each day that passes before trial is a further opportunity for Mr. Waldman on plaintiff's behalf to smear defendant's name, tarnish her reputation, and irreparably damage your career. Again, you see that. That notes fear. That notes damage. Oh, got to get out of the crosshairs now. As alleged in AH's counterclaim, this has long been plaintiff's stated goal. Plaintiff should not be permitted to delay the trial and continue causing this damage simply because there is a scheduled movie shoot conflicting with the trial and for which he has made no effort to schedule around his deposition and this trial. This case needs to end and end soon. Defendant has the right to a prompt resolution of this matter, and this court should not favor the plaintiff's last-minute request in lieu of this court's policies and procedures, particularly where plaintiff has engaged in a pattern of practice of arrogance and disregard for the court's rules, policies, and procedures. Arrogance, indeed. The motions for continuance should be denied, and the plaintiff should be ordered to appear at his deposition, as noted. So in addition to that main documentation, you have supplemental documentation as well, and it has a deposition schedule for AH's team. Now, if you look at these names, I'm sure you recognize a lot of them, and some of these add-ons, they are quite interesting. Trinity here, for example. Trinity Esparza, I always butcher her name, so I hope I got it right there. She's the one that alleged it wasn't Johnny Depp. It was the rocket egg that probably did all of that damage. Cornelius Harrell, he also said, hey, when I was working as a security guard, you know who stayed over a lot? Yeah, and on and on and on. You see names on this you're not familiar with, too. Like I said, there are new things that are going to appear in this case. Now, a thing that I want to leave on is this. You have letters that are attached to this, too, writing Warner Brothers, bringing up the fact that, hey, Johnny Depp is in litigation and X, Y, and Z. That needs to happen for me. Now, that, it seems like a strange way to move forward, considering AH is working with Aquaman too, unless, of course, she has an in card with Warner Brothers. I think people should bring this stuff up, considering Warner is having some huge problems. I'm going to put that in a video, but like I said, I mean, they are having monumental issues, and they can't afford this kind of flack. I mean, if anything, Johnny Depp was doing them a favor by not pulling them into it, and yeah, I'm curious what other people see in that. But anyway, leave me your comments on this. I would definitely recommend you check this stuff out too, because we're going to see new stuff in 2021. We're going to hear new things. I mean, if you think you saw it all with the Johnny Depp versus the Sun trial, you ain't seen nothing yet. I mean, nothing indeed. But anyway, let me know what you think. So to close this out, I want to say thank you. I appreciate you. You make these endeavors possible. Without you, none of this stuff works, and that is truly appreciated. I can't say that enough. I want to mention the fact that we're about 200 subscribers away from 100,000, so if you haven't subbed to the channel, consider it there, and check out the links in the description. One of those is another case for The Littlest Umbrella. This is our second comic book. First one's also attached, and we could use your help getting the word out because, well, a lot of sources out there, they don't want us to have that thing. But like I said, thank you regardless. We appreciate the heck out of you. You being here, it makes this stuff work. So thank you. Appreciate you. Leave your comments and see you soon.